Good afternoon. This afternoon I'm going to look at a few aspects of the Planning and Development Act 2010. Half an hour would not allow me to look at all of them, so I've just chosen a few of those which take my fancy, and I have to confess that the amendments in relation to the quarries, section 261, definitely did not take my fancy, so I won't be covering those this afternoon. But I want to look a little bit at the changes to the Planning and Development Act, in particular with reference to development planning and the planning authority's planning function, and then also some changes referable to the planning permission process. One of the key changes referable to the development plan and the planning authority's function relates to the requirement for a core strategy. So a planning authority must now develop a core strategy which will underpin its development plan. And basically, the Planning and Development Act is requiring a much more reasoned approach by the planning authority to planning for development in its functional area. And this core strategy has to show how the development objectives of the planning authority are going to be in compliance with the National Spatial Strategy and Regional Planning Guidelines. So there's a much greater emphasis on compliance under the Planning and Development Act 2010 with the National Spatial Strategy and then also with regional planning guidelines. And we'll see later how the Act has given an enhanced role to the Regional Planning Authority in the whole planning process, and how local authorities' function and role in planning is going to be very much more circumscribed. And it's perhaps a little ironic that in the introduction or the preface, the explanatory memorandum that came with this bill, when this Act was first introduced as a bill, and it said that it would support and enhance the democratic local decision-making process. But in my own personal view, this Act does nothing of the sort, because it very much more constrains planning authorities in how they carry out their planning functions, because more and more they're going to have to pay much more heed to the National Spatial Strategy and to regional planning guidelines. So this core strategy which they're required to prepare must show that the development objectives, as I say, are consistent with the National Spatial Strategy and Regional Planning Guidelines. As you know, the development plan consists of a written statement and plans, and that written statement must include a separate statement showing that the development objectives are consistent also with conservation and protection of the environment. And you'll see that phrase again recurring throughout the Planning and Development Act 2010 amendments, this phrase of conservation and protection of the environment, and a new emphasis on that for planning authorities and for the regional planning authorities. In the core strategy, the planning authority has to provide relevant information to actually show how the development plan and its housing strategy are consistent with the National Spatial Strategy. So they're actually going to have to put an evidence-based approach from the planning authority showing how these plans are actually consistent with the National Spatial Strategy. And in their core strategy, they're going to have to show the lands which have already been, they're going to have to set out the acreage or hectares which have already been zoned for development, what number of houses were built on those lands, and then with reference to future zoning decisions, they're going to have to set out what acreage of land they're proposing be zoned for residential development and what are the projected number of houses for those lands. So they're going to have to set out a lot more detail, their thinking or reasoning in relation to zoning and housing policy. In addition, as part of the core strategy, they're going to have to set out their settlement hierarchy. And in setting out the settlement hierarchy, they're going to have to show what towns were designated under the National Spatial Strategy as hubs or gateway for development. So the National Spatial Strategy was first drafted in around, I think, 2001 and 2002, and it identified various towns as gateways or hubs for development, and it would have done that on a very rational and reasoned basis, looking at access to public transport, looking at where they were located, what urban areas were beside it, and it identified those towns as gateways or hubs at which development should be focused. However, for the last number of years, the National Spatial Strategy, to some extent, has been paid lip service by planning authorities in their planning function. But, as I say, under the Planning and Development Act 2010, the National Spatial Strategy is going to play a much, much greater role and have much more emphasis and importance in the planning function of the planning authority. The Planning Authority also, in drafting this settlement, setting out the settlement hierarchy, showing those towns that have been designated as gateways and hubs, they're also going to have to deal with their projected population. So what are their current population targets, what is their current population, and what are the projected population targets in the future? And they're going to have to set out how their policies are consistent with government policy in relation to regional and national population targets. So they're going to have to set out their settlement hierarchy on a much more reasoned basis, having regard to figures relating to population, current population and future population in their area. And also set out their settlement hierarchy with reference to transport routes and what are the available transport routes, what are the road transport, rail transport, etc. So a much more reasoned approach to how they're going to plan for the development of their towns and cities. The settlement hierarchy, that term is actually defined under the Planning and Development Act 2010, and it provides that a rank is to be given by the planning authority to those towns or cities that have a population, or areas that have a population of over 1,500 people. And the settlement hierarchy, the ranking has to be given on the basis of designation under the National Spatial Strategy and on the basis of an assessment by the local authority of the function or role of that town or city in the context of the National Spatial Strategy, and also on the basis of the potential for economic and social development of that town or city, and also having regard to ministerial or government policy or function in relation to government policy objectives for planning and development. So much more planning having regard to population, having regard to transport availability, having regard to population as it currently stands or projected population growth, and then also having regard to ministerial or government policy in this area. Also, in reviewing and varying a development plan, once again a planning authority are going to be constrained in many ways, because as you know, there's a whole statutory procedure to be gone through when a planning authority proposes to vary its development plan or to introduce a new development plan. And now, as part of that procedure, the county manager is going to have to prepare his report following the whole public consultation procedure on the introduction of the new development plan or the variation of that development plan. There's a whole consultation procedure, and now the county manager, once that procedure has finished, will be drafting a report. But in that report, he's going to have to look at any recommendations that the regional authority made in relation to this development plan. So, as I say, the regional authority has a much greater role in shaping the development plan and influencing the look and outcome of that development plan. Now, the county manager is going to have to look at any recommendations that are made by the regional authority. He's going to have to do a report on any recommendations made by them, and he's going to have to explain why the local authority may not be following any recommendations being made by the regional authority. So he's going to have to set out a reasoned basis for why they would not actually be following the recommendations of the regional authority. There's also a new provision. As you may know, under the development planning process, planning authorities can make a modification to a development, can make a modification to a variation to the development plan. So if a planning authority is proposing to make a variation to its development plan, it goes through a full public consultation procedure in relation to that variation to the development plan. But what can happen, and has happened in some instances, that the planning authority, once they've gone through that public consultation procedure on the variation to the development plan, they decide, well, actually, we want to change the variation a little bit. We're going to modify that variation. And in that way, the modification to the variation goes under the radar. It isn't subject to the same public scrutiny as the actual variation. What the Planning and Development Act again now circumscribes that, and the planning authority can only make a modification to a variation if it is not going to be substantial in nature. and it's one that's not actually going to trigger a requirement for a strategic environmental assessment or appropriate assessment. So again, pulling back the planning authority so they can't actually make these modifications to variations if that modification is itself going to trigger a requirement for a strategic environmental assessment or an appropriate assessment. In addition, it can't be made where the proposed modification would actually be to increase the area of land being zoned for residential development. So again, the planning authority cannot at the last minute sneak in a modification to a variation of a development plan that would effectively increase the area of land to be zoned for any particular purpose, nor can they add to or delete from the record of protected structures by way of a modification to a variation. So once again, a circumscribing of the powers of the planning authority in relation to making modifications to variations of a development plan. As I mentioned earlier, regional planning guidelines have been given a much more enhanced role in the planning process. And the regional authorities around the country, as you know, there are functional areas for each planning authority, but also on a more macro level, there are regional areas, and regional authorities are in charge of drafting regional guidelines for their regional area. And they are drafted every 12 years and set a template for a much longer period than, say, the development plan is for a period of 6 years. And now the regional planning guidelines contain an express reference to the National Spatial Strategy. And it must be the objective of those regional planning guidelines to support the implementation of the National Spatial Strategy. So when the regional authorities are drafting these regional planning guidelines, they have to do so in such a way that expressly supports the implementation of the National Spatial Strategy. So again, we see the importance and the emphasis being given on compliance with the requirements of the National Spatial Strategy. And they have to do so by providing a long-term strategic planning framework for the development of that region in accordance with the National Spatial Strategy. The regional planning guidelines have to also address ministerial or government policy in relation to population. So once again, you have to see a much more reasoned approach to planning based on what are the current needs of the population, what is the population, and what are the projected needs in the future. Interestingly, also under the regional planning guidelines, there's a new requirement that they address landscape policy. So under the European Convention, the regional planning guidelines have to address what their requirements are in relation to landscape preservation. Also on the promotion of sustainable development and transportation strategies. So again, the regional planning guidelines set out how they're going to plan for sustainable transportation strategy in urban and rural areas. Also set out measures to reduce anthropogenic greenhouse gas emissions. The regional authority has to set out in guidelines what measures should be promoted to do that. Also, the necessity to adapt to climate change. So the regional authorities should again address in their guidelines this necessity. As you know, under the Planning and Development Act, there's a lot of mention of planning authority must have regard to, the board must have regard to, and this expression to have regard to recurs throughout the Act. However, this phrase to have regard to was interpreted in a High Court case a number of years ago in McAvoy against Meath County Council. And what does it mean? What does it actually mean in terms of compliance by the planning authority or the board with the things with which it's required to comply under the Planning and Development Act? Now, unfortunately, in that High Court case, it really gave a very low level of compliance to this expression to have regard to. The High Court said, well, it doesn't mean that you have to slavishly adhere to. It means no more than that, that you can have regard to. So in other words, a planning authority could say, well, yes, I had regard to, but I decided to disregard it. So that meant that you had, where there were expressions in the Planning and Development Act that you had to have regard to ministerial guidelines, it meant that really there was quite a low level of compliance required by the planning authority or the board in respect of those. So the Planning and Development Act 2010 amended that and now provides that rather than the planning authority having regard to regional planning guidelines, it must ensure that the development plan is consistent with any regional planning guidelines. So a much greater onus on the planning authority to ensure that their plan is consistent with the regional planning guidelines. So again, a much more constraint on the planning authority in their planning process, that they have to defer to these regional planning guidelines and show and set out how the plan is consistent with regional planning guidelines. If the planning authority is doing a draft development plan, then the regional authority have an opportunity to comment on, well, they have to actually comment on that, and they prepare submissions on the draft development plan. And they set out matters that require consideration by the planning authority. So if the regional authority thinks that the development plan is not in fact, or the proposed development plan is not in fact with their regional guidelines, then they can set that out in a report and they can make recommendations. And the kind of things that they consider in that report are best distribution of residential development, objectives of providing physical, economic or social infrastructure, planning for best use of land, and then collaboration between the planning authority and the regional authority on integrated transport and land use. So when that planning authority is doing the draft plan, the regional planning authority can report back on whether the plan and the core strategy actually accord with or are consistent with the regional guidelines. And if they're not, they can make recommendations or say what amendments would be required to the draft plan to actually make it consistent with the regional planning guidelines, and that report is sent to the minister. So it's a bit like a school report for not performing, didn't do very well, this plan is not in fact consistent with the regional planning guidelines. But by sending that report to the minister, it's also triggering the potential for the minister to issue a directive to the planning authority that it must ensure that the plan is consistent with the regional planning guidelines, because under the Planning and Development Act the minister is empowered to issue directions, and we'll look at that in a moment as to how those powers are actually enhanced. So the planning authority, we have again still have this phrase, must have regard to ministerial guidelines, but I suppose they're boxing clever here, because after the expression must have regard to, they put in a paragraph that says that in having regard to the planning, the planning authority must consider the minister's policies and objectives. So they can't just have regard to, they actually must consider the minister's policies and objectives, and they have to append a statement to the development plan. So they actually have to draft a statement, append that to the development plan, showing how the development plan actually accords with the regional planning guidelines, and show how the policies and objectives of the regional planning guidelines have actually been implemented in the development plan. So they have to put that statement into their development plan. And if it hasn't been possible to implement the objectives of the regional planning guidelines, they have to set out a reasoned analysis of why it was not possible and why they haven't done so. But again, potentially triggering a ministerial directive for not doing so. Under the Planning and Development Act, as you know, the minister, as you may know, the minister has power to issue directions to a planning authority in respect of their planning function. Now, up until a couple of years ago, it wasn't very widely used. Minister Gormley was perhaps more fond than others of using the power, and did on a number of occasions, with some success on some and less on others. But now there are enhanced provisions, I suppose, in relation to ministerial directives. And if the planning authority has not actually taken account of ministerial submissions on the development plan, or if the plan actually fails to set out an overall strategy for the proper planning and sustainable development of the area, if the development plan is not in compliance with the planning acts, then the minister can actually direct the planning authority to take certain measures. So he has this executive type power, I suppose, to direct them to take measures. However, I suppose the minister really doesn't want to be seen to be issuing a fatwa, so we now have a public consultation procedure in relation to these ministerial directives. So that now, rather than him just issuing a directive, he issues an opinion, or he says, I'm of opinion that I should issue a directive, and he serves notice of his intention to do so. And then you go through a whole public, well, the planning authority then has to go through a public consultation procedure in relation to that draft directive. So the Planning Authority has to publish notice that they've received a draft directive, and they have to invite submissions and observations on the Minister's draft directive, and they can themselves make observations on it. Once the public consultation procedure closes, the manager makes a report on the submissions he has received, and the Minister then considers that report and decides whether he's going to proceed with the directive and issue it, or whether he's actually going to amend it. And there's also a facility there for the Minister to decide, well, actually the submissions do raise a substantive point, or clarity is required on this, so I'm going to appoint an inspector to look at my proposed directive. And he can appoint an inspector. An inspector looks at all of the information and issues a report back to the Minister, and the Minister then decides whether he's going to issue the directive or not. So there's this whole new public consultation procedure in relation to the Minister's directive. The next aspect of the Planning and Development Act I'd like to look at for a moment are default planning permissions. As you know, if the Planning Authority has failed to make a decision on the application on the last day on which it is empowered to do so, there will be a deemed permission. However, under the Planning and Development Act 2010, this has been amended to give the Planning Authority further grace, so that they now have an additional 12-week period. So if they fail to make their decision in the first period, and this comes to their attention, or as somebody else draws it to their attention, they now have an additional 12 weeks within which to make their decision. And a deemed decision will only be deemed after the expiry of that 12-week period. However, there will be no deemed decision if the planning application is one for which an environmental impact assessment is required, or an appropriate assessment is required, and that's arising from a problematic, from a case in the European Court of Justice Commission against Belgium. But there will be no deemed decision. You cannot have a deemed planning decision if the application is one for which an environmental impact assessment is required, or an appropriate assessment would have been required with that planning application. Then, though, the developer is getting into quite a loop, because if his application is one for which an EIA or an AA is required, there seems to be no actual time, long stop date by which the Planning Authority must actually make its decision in relation to it. Now, there is provision whereby the Planning Authority have to pay back the applicant a certain sum of money, but the Act does say that if the Planning Authority still haven't made their decision after a year, that they can ask the applicant to go back out and publish the notices in relation to the application, but that they will pay him to do so, which I suppose is little comfort for the developer who's been waiting a year for the Planning Authority to make the decision. But that is the position in relation to the default applications. You will not get a default permission if it's one for which an EIA or an AA would be required. There is also, as you know, under the Planning and Development Act, before it was amended, there is a facility whereby the Planning Authority can actually refuse planning permission to an applicant for past failures to comply with planning permissions. And under the old Planning and Development Act, that was where he failed to comply, where the applicant failed to comply with a planning permission, or failed to comply with a condition in a planning permission, but didn't extend to circumstances where somebody actually hadn't applied for planning permission at all. So now that has been amended such that the Planning Authority can actually refuse planning permission where the applicant had carried out substantial unauthorised development. So there's clarity brought to that, so that if the applicant has previously carried out unauthorised development, then that is a reason why the Planning Authority can decide that they are going to refuse for past failures. Under the Planning and Development Act 2010, there's also a new provision in relation to the extension of duration of planning permissions, which will be of considerable comfort to developers who may not have been able to finish a development because they ran out of finance, or for whatever reason in the current economic circumstances they're standing on a half-completed development. Now, under the Planning and Development Act, there are certain preconditions before you can apply for extension of the duration of the planning permission. You have to show that development was actually commenced before the expiration of the permission, that substantial works had actually been carried out, and that the development can actually be completed within a reasonable time. Now, that was the position under the Planning and Development Act 2000, but this has now been expanded so that if the applicant can show that there are considerations of an economic or technical nature as to to why, beyond their control, as to why they couldn't carry out the development. And if they can show that the development is, or the proposed development is not inconsistent with any objectives of the regional planning guidelines, such that it would be no longer consistent with them, or that it's not inconsistent with any new ministerial policy, directives or guidelines, then in those circumstances it can apply for an extension of the duration of the planning permission. They have to show that if, in addition to all of those matters, they also have to show that if an EIA was required or an appropriate assessment was required, that actually had been carried out, and that the application for this extension is in accordance with any planning regulations relating to an application for an extension. The one sting in the tail for the developer in looking for this extension of the duration of the planning permission is that the planning authority can reopen the conditions in relation to financial security for completion of the development, so they could decide to impose greater requirement for security on the developer. There is one application only can be made under this new provision. However, if you had applied for an extension prior to the introduction of this provision, you can apply again under this provision. However, it seems to me it's potentially a problem with this provision, and I just say express this as a thought only, but that if planning permission is given, say, year one, and an extension is given and the development is not actually carried out till, say, 9 years later, it seems to me that the environmental impact assessment directives and the habitats directives that require the appropriate assessment are predicated on a temporal connection, at least, between the time the assessment is carried out and the time that the development takes place. And if you're in fact, because you get an extension to the duration of your permission, not actually carrying out the development until many years later after the assessment has actually been done, the likely, whether or not it's likely to have significant effects, or if it's having an adverse effect on a European site, those circumstances may have changed in the meantime. So it seems to me there may be problems coming down the line in future with an extension of duration of planning permissions. There are substantive changes in relation to retention applications, such that it's going to be much more difficult for an applicant to get a retention permission, in particular where the application was one that required environmental impact assessment or appropriate assessment. The reason for the changes arise from a case what's commonly referred to as the Derry Bryan case, where the European Court of Justice was highly critical of the position in Ireland whereby an applicant could easily apply for a retention application for a development which should have been subject to an EIA but was not subject to an EIA, because the EIA directive requires that an EIA be carried out prior to the consent being given for the development. And this easy facility in Ireland to the retention application did not accord with the requirements of the EIA directive that EIA be carried out prior to the commencement of development. So now, under the new amendments under the Planning and Development Act, you won't get a retention application if the application was one for which an EIA was required, screening as to whether an EIA was required, or one for which an appropriate assessment should have been carried out under the Habitats Directive. It's simply not possible to seek retention now for those, save in relation to, and I'll deal with the moment, those for which substitute consent may be available, but those will be exceptional cases. But the effect of this is that somebody who's now carrying out a development, say a wind farm development, which is one for which an AA should have been carried out or an EIA should have been carried out and wasn't, and they now need, say they're doing design changes mid-project and they need to go back for a retention application, well, that is now highly problematic for them and a very difficult situation for a developer to find himself in. So there is this new provision, that is this derogation that provides for a substitute consent. So for those developments which should have been subject to an EIA, for which screening should have been done or for which an appropriate assessment should have been carried out, they may apply for substitute consent for this regularisation consent, but it is really only to be in exceptional circumstances. And I think the thinking on this is that it is really to deal with legacy and historic situations and will not be used going forward. There's a whole procedure to be gone through in relation to applying for substitute consent, but basically you have to apply to the board for leave to apply for substitute consent. The other way of doing it, the developer can apply directly to the board for leave, or the planning authority itself can serve notice on a developer requiring that application be made for substitute consent. So the board can consider the application and decide whether it's actually going to give leave to the applicant to apply for substitute consent, but it will do so only in exceptional circumstances. And I think Duncan is going to touch on this, so I won't go into this in too much detail. But the board can, when looking at the application for substitute consent, direct production of a remedial environmental impact statement or a remedial Natura impact statement. So this is one for which an EIA should have been done or an AAA should have been carried out but wasn't, and it can direct that a remedial environmental impact statement or remedial Natura impact statement be provided with the application, and a public consultation process will take place on that application. The board is empowered to direct cessation of activity on the site while it's considering this application, and it can grant consent for it, it can refuse consent or give consent subject to conditions. If it refuses consent, it is empowered to order the developer to cease the activity and to take remedial measures. But if substitute consent is given, then that's the same effectively as if the developer had got planning permission. If he's refused substitute consent, then it's an unauthorised development and enforcement proceedings can be taken against that developer. So very serious consequences for a developer who's in that situation of having to apply for substitute consent, because if he doesn't get it, he's then unauthorised development and is open to enforcement proceedings. Then just finally to mention, in relation to energy developments, there are a few changes affecting, say, developers of wind projects, such that a strategic infrastructure had a very high threshold before you would be classified. If you're a wind farm developer, it was very high before you would be categorised as strategic infrastructure. So that has now changed and has come down from, if you now have 25 turbines or have a total megawatt output greater than 50 megawatts, you can come in under the strategic infrastructure and apply directly to on board Planola. And also forest roads, the provision of access to a forest road is no longer exempt to development, so that may affect wind project developers. There's some amendments in relation to gas infrastructure, particularly with reference to gas infrastructure, the requirement to produce a Natura impact statement if the development is likely to have a significant effect on a European site. And then also amendments in relation to electricity transmission lines, again an express requirement for the production of a Natura impact statement if it's likely to have a significant effect on a European site, and also an amendment to the provision whereby the board can get payments of its costs in relation to the application, and it can also direct payment of the costs of the planning authority and the costs of any other person. So the board is given greater powers in dealing with cost issues arising in electricity transmission lines. A subject that will be dear to the heart of many people here today are the changes relating to judicial review. One of the changes relating to judicial review is the telescoping of procedures. As you know, or may know, that under judicial review there can be two protracted procedures whereby an applicant applies to the court for leave to bring judicial review, and then, having gone through the whole application on leave as to whether or not it is entitled to bring the case for judicial review, there then is a later substantive hearing on the substantive arguments in the case. So you effectively have two hearings, and the new Planning and Development Act 2010 allows now the telescoping of those two, so that you can telescope them into one hearing and effectively all the issues aired at one hearing. There is new provision in relation to costs, so whereby under certain challenges, judicial review challenges, particularly relating to environmental matters, so any decisions that relate to the Strategic Environmental Assessment Directive, the Environmental Impact Assessment Directive, the IPPC Directive, judicial review challenges relating to those, each party is to bear its own costs. Now, that is a very significant disincentive for environmental objectors to bring a case to the High Court, because prior to this people would have been prepared to take a risk that maybe on some cases they will get their costs, and that will give them a war chest or a treasure chest in funding other actions. But now, where there's no possibility of getting any costs in any of these cases, it's a very significant disincentive for those parties who genuinely feel aggrieved at the implementation of a directive, a transposition of it, or how the board or the planning authority party have interpreted it, because now either party, they have to bear their own costs. There's no possibility that they're going to recover their costs. The court still has a discretion where a claim is frivolous or vexatious, and can also decide if there's a point of law of exceptional public importance to give a party its costs in those circumstances, but they're quite limited circumstances. So that's all I want to say about those few provisions of the Planning and Development Act 2010 that I have looked at, and thank you very much. I'll be happy to take questions later on. Thank you.